Well, Amy, the screen says live. I don't know if we're actually broadcasting live, but we're going to wait just a little bit and let everybody get logged in. We're scheduled to actually start at 1 o'clock today. And if anyone's already logged in, I'm Brad Bodis, and this is my law partner and good friend, Amy Tanner, and we're going to get started at 1 o'clock with our presentation. I'm just hoping that we don't get, we've got some bad weather here near Birmingham, Amy. How is it in Huntsville?
Same. Right here at the office, it's okay, but my husband just texted me from about 15 miles out of town and said it's really storming there. Well, so, yeah, I'm hoping we don't get hit with something.
I hope our listeners don't have to hear lightning and thunder in the background today.
I hope not. You know, we just celebrated or you don't celebrate, I guess, but we just passed the anniversary of the April tornadoes, 2011. So.
Oh wow.
Don't need any more of those, especially right now.
Well, Amy, I see that we already have some folks that are logging in, so we may get started just a little bit early here. Okay. Just for those that are already logged in, I'm Brad Bodis, and next to me, although she's a few miles away, is my good friend and law partner, Amy Tanner. Again, we're just going to pause just for a second. Just as background, this is actually our third Facebook Live presentation. First one where you get to see somebody else other than me on the screen, which I know is a relief. And we're going to continue to do these presentations every Wednesday at 1 o'clock p.m. That's Central Time for as long as this COVID-19 pandemic continues. We just, Amy and I and our other attorneys sense quite a bit of anxiety and stress out there for people that are unable to pay their bills, that are unable to work right now. And we just want to let you know that there are options available. Bond and Bodis, we've been helping people with financial problems for over 3 decades now. And we're going to be here through the long run and available to help you if you need help. So I'm going to get started now. Again, I'm Brad Bodis. Next to me is my good friend and law partner, Amy Tanner. Amy works primarily in our office in Huntsville, Alabama. She spends some time in Decatur, Alabama, and really serves as a mentor and helper to the attorneys in all of our offices. She's practiced bankruptcy law for quite a long time, and I'm just fortunate to have her as a friend and a law partner. So, Amy, welcome today, and I'm glad you're participating.
Thank you, Brad. I feel the same.
All right. So, last week we focused on your 45-day window. A lot going on right now. You have a good period right now to reach out, get your credit reports, and make sure that your credit reports are reporting accurate information right now. Keep in mind that it's not just the business you may be affiliated with or that you might work with that's perhaps not going 100% right now, but the same thing is true for the credit reporting agencies and the collection industry. And the reason that's important is because if you find an error or information that shouldn't be on your credit report and you challenge it in the proper manner right now, if they can't verify within a reasonable period of time, usually within 30 to 45 days, they have to remove that information or at a minimum mark it as disputed. So they may be shorthanded and unable to verify quickly. Take advantage of that. Reach out, get your credit report now. In addition to what we're going to talk about today and how to deal with debt issues that may face you going forward, make sure that credit report is clean. And we have good detailed information on our website that will tell you how to pull your credit report and how to challenge information in the proper manner. There's a correct way to do this. One of my other law partners and good friends, Ron Sixtus, has written on this extensively. There's a tab on our website that refers to credit reporting issues. And then there's also, if you go to our blog, we've blogged on hundreds and hundreds of different topics, and our blog is completely searchable, and you can go there for some great information on cleaning up your credit. But take advantage now of this opportunity you have. As I've said in the last 2 Facebook Live presentations, don't just sit back right now. Be proactive. Reach out. Contact your creditors. Get a plan in place for the future. Now, the bond and bonus law offices, I told you that Amy Tanner works primarily out of our Huntsville and Decatur offices, and I'm normally in our Birmingham, Alabama office, but we have offices in Tennessee, across Alabama, across Mississippi, and we're available to help you with financial matters right now. Important for you to know, we are meeting with clients from the safety of your home, safety of your office. We're doing video and phone consultations. We'll meet with you just like we are on screen here today, if you'd like to do it in that manner, or we'll do it by phone. And hopefully, at least here in Alabama, the state's getting back to work slowly. It won't be long before we'll be doing in-office consultations again. But I want to kind of lead things off here by talking about really the big elephant in the room right now, and that's just the fear and the anxiety that people are dealing with right now. Most of us have never been through anything like this before, Amy. We're not able to work. Mortgage payments, so we're getting ready for really the second payment to be due since this whole thing started. Car payments. People don't have the money available to make those payments, perhaps. But there are ways that you can be proactive, and there are ways that we can help you to protect your assets. And that's why, again, I want you to get a grip, get a plan in place, reach out to us. It's never too early to seek help. You see our phone number and our website address on the screen in front of me. We're offering absolutely free consultations with a qualified, experienced attorney. No obligation. We'll just talk through your situation. I don't want you to wait until it's too late. Until perhaps you've already lost your car to a repossession or are facing a foreclosure. Today, we're going to talk specifically about an area of the law that Amy Tanner has particular expertise and experience in. Many people right now, they think they can't pay their bills, that a Chapter 7 straight bankruptcy may be necessary, and that's kind of scary for people. But there's another option that I think under these particular circumstances may really serve people well. And that's to look at another option provided by federal law, and that's a Chapter 13 debt consolidation, where you don't lose assets, you don't wipe out all your debt. It's kind of like the way I explain to people, Amy, is you hear of big businesses doing Chapter 11 reorganizations and keeping afloat. A Chapter 13 debt consolidation is an individual reorganization. It's a way for you just to get some breathing room to stop a foreclosure, stop a repossession, stop a lawsuit or a garnishment, put together a plan to work your way out of debt. We've certainly helped plenty of clients with straight bankruptcy, but we do a lot of Chapter 13 reorganizations, debt consolidations, and I wanted Amy here to address Chapter 13 and how it works. So, Amy, we've already got a few questions posted here, and you're the expert on this, and I'm going to pose these questions. She's smiling, but she is, folks. She's been doing this a long time, and she's well respected. I'm going to pose a few of these questions to you. tell me exactly how is Chapter 13 debt consolidation different from straight Chapter 7 bankruptcy?
That's a good question, Brad, and I get asked that all the time. And that's one of the things we discuss with you in a free consultation and make it specific to your situation. But today I'll talk a little more generally. And I'm actually going to start with the one thing that is the same, and that is the end result is a discharge and a better credit situation. They are different in that you have a lot more you can accomplish in a Chapter 13. Chapter 13 we refer to as debt consolidation because that's exactly what it is. We take pretty much all of your bills. Unlike some of these debt management plans that can't handle all your creditors, they can't take your secured creditors. Secured creditors can be taken care of in a Chapter 13 plan. Tax debt can be taken care of in a Chapter 13 plan or some other debts along the lines of tax debt. Plus, you can take care of your unsecured creditors, your loan companies, your medical bills. You may not have to pay all those creditors in full in a Chapter 13. I think we're going to talk about that some more, but that's one of the big things that people don't realize about a debt consolidation. But the big difference is one is more of an immediate fresh start, and that's the Chapter 7. And although it sounds like a good thing, it's not always the best option for you. Chapter 13 is a little bit more of a long-term commitment to pay your creditors, maybe for the sake of paying creditors, reorganizing debt, as you pointed out, just like a company would reorganize debt and keep afloat. It's exactly what an individual can do, is instead of having that overwhelming feeling of having 10, 15, 30 payments due per month, they have one payment due per month.
We often get calls from prospective clients, and they feel that bankruptcy may be a one-size-fits-all, and they're, I guess, just calling. They want to know how much a bankruptcy costs, and I always warn those people that if an attorney quotes you a fee over the phone, it's possible they're just treating you as a commodity or as a number, because bankruptcy is not one size fits all. Sometimes a straight bankruptcy is what you need, but in many cases, a Chapter 13 reorganization is the best option, in particular now where people want to protect their home, want to protect their car, don't want to lose any of their assets. They just want to put something together to get them back on track. In our firm, we offer that free consultation so that we can talk to you about your particular situation. Again, you don't pay any money at this point. We talk you through your situation. And frankly, our first objective is, if we can, we keep you out of bankruptcy. We look at other options, and we'll talk through those and answer questions. But if bankruptcy is right, you need to find the right type of bankruptcy. And going even further with a Chapter 13 bankruptcy, as Amy just explained, what percentage you pay to your creditors is important. How you treat different secured creditors is important. How you treat obligations such as taxes or perhaps back child support if you've gotten behind during this current pandemic. All of those issues can be addressed, and it's important to sit down with an experienced attorney. Again, you don't want to just be quoted a fee, pay a fee, and go through a quick process. You want somebody that's going to help you in the long run and do what's best for you in the long run. Amy, I see a few more people are logging in here, and some more questions are starting to come in. Let me ask you this. Who in your mind is a good candidate for a Chapter 13 bankruptcy?
Well, that's a good question too, Brad. For the most part, people are suffering the fear and panic and thinking Chapter 7 is the answer. And to your point, everybody's situation is different, so it's worth a talk through. What I'm finding a lot are who are the best candidates for a Chapter 13, and the way to be in a Chapter 13 is to have some form of income. First of all, it needs to be, you may just be you may have reduced hours at this point. You may not be completely out of a job. You've got reduced hours, but you're needing to hang on to your car. maybe catch up on some house payments. That's a great candidate for a Chapter 13 when you still have some kind of income coming in to pay with, but just not enough to go around to all your creditors as they sit outside of bankruptcy. So someone who just needs to get a grip on the debt and get it in a manageable payment. Another person is someone who has assets to protect, and you've worked hard all your life for an asset you may have, whether it's equity in your home, a car, or even other things that you may need to protect from your creditors. Great for 13 when you're trying to protect an asset. We can work a plan that definitely does that so that you don't lose anything you have worked hard for. And another thing, you do have to qualify income-wise to file a Chapter 7. So you may be what's called an above median income debtor, which means you make more than the median income that is set for your locality by state and even down to region in some places. And if that's the case, you may not be eligible for a 7, but we can definitely fit you into a Chapter 13. So I always say, pretty much everybody, anybody can file a Chapter 13. So almost everybody is a candidate in some way or form for a Chapter 13.
That's exactly right. And I should point out now, across the bottom of our screen, we just posted today on our blog an excellent blog post that Amy wrote, as a matter of fact, about how a Chapter 13 bankruptcy works with a lot more detail. The link to the blog post is across the bottom of the screen, but you can also, if you don't want to fill out all those dashes and words, you can simply go to our main website and click the tab that says blog, and it's the lead blog post today. And although, Amy, I think I'm correct, this blog post pertains to how an Alabama Chapter 13 bankruptcy works. I think people are going to find the basics are going to be pretty much the same in all of the states in which we practice. Would you agree?
I agree with that, Brad. Your basics are pretty much the same. There are little nicks and knacks that vary from region to region that has local rules, but I believe, the way I wrote that, it would pertain to, just about anybody in general.
Well, it's an excellent blog post, and I encourage people that need more detail to go there, and of course, just search our blog in general. All right, another question I see here, Amy, is if I file Chapter 13, can I keep my assets? Can I keep my house and my car?
Absolutely, Brad. When you file the goal when you file a Chapter 13 for me is to not lose anything you need or that you don't necessarily want to lose. Now, there are certain luxury items you might want to take the opportunity to get rid of in a Chapter 13 or lose the obligation from. But no, if you have equity in your home, we can protect it in a 13. As I said, that's a great reason for filing 13. You keep your cars in a Chapter 13. In most areas, you would pay those cars as part of the payment plan. So you shouldn't generally lose any assets if your Chapter 13 is crafted properly by somebody who has experience doing so.
But I think you make an excellent point. You can pick and choose. If you perhaps, before this all started, thought you could afford an expensive car or a motorcycle maybe, or something just to have in addition to what you use for your regular transportation, this might be the time to shed yourself of that and have the plan still provide for you to keep the vehicle and the assets that you do need. All right, a couple more questions, Amy. Somebody wants to keep their home, but currently they're unable to make their house payments. They're out of work right now because of this pandemic, and they're behind, or they're unable to make their house payments. Is Chapter 13 going to help that person to keep their home?
Brad, it will, and that's another good reason to file a Chapter 13. Maybe you've missed April's payment and now you're about to miss May's payment. You could be going back to work very soon, but that doesn't help you catch up. Maybe your mortgage company even allowed you to skip a few payments, but now they're calling them due all of a sudden and say, now you have 3 or 4 payments due on your house. We're going to foreclose if you don't make these payments or whatnot. A Chapter 13 can definitely help you, because what we can do in a Chapter 13 is cure arrearage, cure any payments you're behind in a Chapter 13. So if you've missed 3 or 4 payments and you're struggling and wondering, how am I going to catch the payments up? No more worries. We can put those in a Chapter 13 plan. Now, in most instances, you do have to resume your house payments at some point. But this is another reason to call for a free consultation and talk to one of us, because it may be just a little bit of bankruptcy planning. Hey, you're going back to work in June. Maybe we need to wait till June to file so we can include June's payment and get you through that long. As long as there's not a foreclosure date pending, you may have a little bit of wiggle room in planning when you should file, so that you can cure the entire arrearage in a Chapter 13 plan. I'm going to go out in the weeds a second for here, but this is something I've noticed personally in my own practice with, on a go forward basis. Some people tell me, I can't afford my payment. This 13 sounds great to catch it up. I can't afford the payment. This is really a little bit outside of Chapter 13, but it's just kind of something I've noticed. No guarantee, not really part of the 13. But I have noticed that a mortgage company will, say they'll work with you on a modification of your payment on a go forward basis. Doesn't really happen. The foreclosure train's still going down the road while the modification train's still going down the road. We can file that 13 to stop any foreclosure, but what does that do to a modification? Does not stop you from getting a modification in the future. You can still, once we file that Chapter 13, work with your mortgage company to modify your payment. And in reality, or what I have noticed is, I said kind of in the weeds a little bit, but what I've noticed in my practice is a lot of mortgage companies, for some reason, are more willing to do that modification once you file the Chapter 13 than before you have filed it. I don't know what the rhyme or reason is. There's a lot of rhyme or reasons with mortgage companies I don't understand. But I see that happen all the time. And the court oversees it to make sure you're not getting a raw deal from the mortgage company. Your attorney and or the mortgage company may file a motion or joint motion to approve a modification. So that, actually getting into the 13, getting the arrearage cured, does not stop you from modifying your mortgage down the road to help you with that monthly payment on a go-forward basis.
And you just led to another good topic here. And I don't think it's in the weeds. I think it's something people need to be aware of. You often get mixed messages from mortgage companies. They'll tell you they're working on a modification at the same time they're working on a foreclosure. Well, the mixed messages they're stronger now than I've ever seen them. I hear some mortgage servicers are going to let you get behind 3 months, but then have to catch them up at the end of the 3 months. Now there's some news that says that won't be the case with certain government guaranteed type mortgages. But as I've said so many times, if you're getting behind on your mortgage, be proactive, reach out, talk to the mortgage company, but then make detailed notes. Don't just, say later, well, I talked to somebody when I called them and they said this. Get the name of the person you talked to, make a note of the date and the time you called, the number you called, and then follow up whatever you were promised or whatever information you were given with an email, or even better yet, a certified letter to make a record of what was promised to you. Because it's hard to prove that you just had a conversation with somebody when you called the mortgage company at some point a few weeks ago. We need details, and you need the details to protect yourself going forward. Amy, you mentioned, all right, so somebody may be behind with their April payment, May payment. What if they're already in foreclosure? What if a foreclosure sale date's already been set? Will Chapter 13 help in that instance?
Absolutely, Brad. If you're facing a foreclosure and you have a sale date set, this means you've probably received a certified letter from an attorney. It means you may have seen it advertised in the newspaper that your house is going to be sold on X day at X time. As long as you get to us before, certainly I have a preference of way before, but as long as that foreclosure sale date has not taken place, we can file a Chapter 13 and stop that foreclosure. So I usually tell people the only thing a creditor can do that I can't undo is hold that foreclosure sale. So up until the point of the foreclosure sale, a Chapter 13 will absolutely stop the foreclosure. Again, as I said a few minutes ago, all the payments you're behind, all the fees and costs that have built onto your account, interest, whatnot, through that date, we can cure over a 3 to 5 year Chapter 13 plan, and you can hit the ground running the following month with your regular monthly mortgage payment. You don't have to play catch up. You don't have to stress about where all this money's coming from or where you that you have no place to go. We can definitely stop a foreclosure with a Chapter 13.
Let me underscore. I said Amy's a great attorney, and she just said all the way up to the date of the foreclosure sale. And we can, but please don't wait until the day before the foreclosure sale. Please get to us sooner than that so we have time to make good decisions for you. We're certainly in your corner, and we're certainly going to help whenever you get to us and do our best. But the more time you give us, the better off we are. So, Amy, I see a question here. What happens with money I have in my 401k, money I've been saving up for retirement when I file either a straight bankruptcy or a Chapter 13 debt consolidation?
Brad, in either kind, any bankruptcy, a 401k, and just about all retirement plans are what's called exempt property or an exempt asset. These things you've worked for and put away in a retirement account are protected from your creditors by law. Whether it's $10,000, $50,000, $100,000. It's protected by law. Your creditors cannot get to that. That's one of the things I advise, all my Chapter 13 clients are people, and that really opens a door to another thing to discuss about people who don't know what to do right now. Some people will try to avoid bankruptcy and look to cashing out a 401k. Again, I'm going to go off in the weeds here. But look to cash in a 401k. Bad advice. Don't do that. You're taking money that is exempt from your creditors that you have saved for yourself to be able to retire someday, and paying it to those creditors when they can't get to that money as it sits now. You're never going to pay yourself back that much money that you've saved up over the years if you use it to pay creditors. That's, like I said, by law, exempt from your creditors. And so the better option for most folks who are facing that right now, if they're cashing out a 401k or retirement plan, don't do that until you talk to a bankruptcy attorney, because you can probably recover from a bankruptcy a lot quicker than you can pay yourself back all that money you just took from retirement and gave to your creditors that they didn't.
Amy, that's an excellent point. There's so many things that people can do before they come to see us that can make our job a lot tougher. And that's, again, why I encourage people, reach out now, reach out before things get really bad, take advantage of the free consultations, and let us address some of these questions. People will come to say, I helped my children pay some large bills before I came to see you. Making large transfers to a family member immediately before bankruptcy can be a problem. But certainly the 401k issue is a big one. I read a post on Facebook within the last few days. It's a young lady that will go unnamed, who was really kind of bragging about the point that her credit was damaged. She got behind on her bills, and she went and took a good chunk out of her 401k to pay those bills. In addition, they held back 25% of the money to go towards taxes, because there are, of course, tax penalties when you take money out of a 401k. She may have been much better off, especially since her credit was already impacted, to have sought either straight bankruptcy or Chapter 13 debt consolidation relief. So please, before you do anything like that, give us a call. Let one of us talk to you about your options. Our phone number and our website address are at the bottom of the screen, and we have people answering calls now, and we can schedule an appointment for you. So again, please reach out to us. All right, Amy, I have a few more questions here, and I want to give you a chance to answer them. Um, well, that one's a repeat. Who can file Chapter 13? Um, how long in a Chapter 13 do you have to pay back your debt?
Good question, Brad. Most Chapter 13 plans are either a 3-year commitment or a 5-year commitment. One of the things that determines whether or not you're making a 3-year commitment or a 5-year commitment can be your income. I mentioned this briefly a while ago. Being an over median income debtor, Chapter 13 may be your only option as opposed to Chapter 7. But also being an over median income debtor would commit you to a 5-year payment plan. If you're an under median income debtor, you may be able to file a 3-year repayment plan. Again, talking to an attorney who knows what they're doing, I'm beating a dead horse there, but can make a difference, because just because you're under median income doesn't mean you need to file a 3-year plan. You can legally, that's what the law says, but it could mean that you have to make a higher payment that's not really affordable. So you may have the luxury to do a 5-year plan. I know there's different local rules in different areas where we file cases. Even throughout Alabama, there are different local rules about maybe who can file a 3-year, who can file a 5-year. But generally, being over median or under median income determines whether or not you file a 3 to 5-year plan. But there may be reasons, amount of debt or what you're trying to keep and pay back, that even though you might be eligible for a 3-year plan, you may want to look at filing a 5-year plan if you're able to do so.
You're exactly right. Many people, it's just getting their payments to a level that they can afford them, and spreading them out a little bit further is going to be the decision maker there. But, as you were talking about 3 years or 5 years, in effect, 36 months through 60 months, that can be a fair amount of time. And yet another reason why you owe it to yourself to do a good job in picking the proper bankruptcy attorney. Again, I hearken back to people that will call and just try to find the least expensive, or the bankruptcy attorney that will say the things they want to hear over the phone. Meet with that attorney. Once it's possible, make sure you get into the attorney's office and meet with his or her staff. Make sure that you're comfortable with the environment, because, Amy, once that bankruptcy's filed, your job's not over, is it? In a Chapter 13.
Not at all, Brad. We're with you the entire 3 to 5 years and beyond. And it's so important what you just said. I'll just say it. I hate to say this about any of my colleagues, but I receive phone calls all the time about, he or she didn't tell me this. Can you help me? I'm not your attorney. I can't help you. I can't answer your questions. I'm sorry this happened to you, but I can't advise you on that. So picking the right attorney is a very big deal, because you're going to be with that person 3 to 5 years, getting their advice. Fill them out. Make sure they're being as honest with you. When I start a process with you, I want you to know everything I know. I may not tell you what you want to hear, and I think that's a bad thing. Some attorneys just want to get your fees up front. They tell you what you want to hear and figure, well, I've got you now. So when this bad thing happens that I know is going to happen, but I'm not going to tell you about right now, you're going to know everything I know, everything I can foresee. I mean, it's going to be that way with any of our lawyers you talk to. We want you to know everything we know. So we may not tell you what you want to hear. We may tell you have to give up your CDU for some reason, or that's been a big one throughout my career, CDUs. We may tell you have to give up your CDU or your Harley, but we're going to tell you why that is, and it's going to be a reason with our experience, we're advising you the best we know how, even though it may not be what you hear. So you're going to be with that person 3 to 5 years. We, as your attorney, are responsible for taking your phone calls, filing motions that you need filed to help you. And all of us at Bond & Motus are going to do that for you, and we're going to hold your hand for 3 to 5 years down the road. The majority plans I file are 5 years, so I expect to have a relationship with all of my clients for 5 full years.
And Amy, again, I'm thinking out loud as you're saying that it really goes beyond the 3 to 5 years. One of the biggest things, and protecting that discharge for you after your bankruptcy. We certainly have instances where a creditor will continue to try to collect or continue to put negative information on a credit report. That's when you really need your bankruptcy attorney, and that's when we really have an opportunity to help you the most. Again, please, if you make the decision to file for some sort of bankruptcy protection, it's one of the most important decisions you're going to make in your life. It's going to impact you in good ways and in tough ways. You're going to have to make some tough decisions. It's important to be working with somebody that you feel good about, that has a staff that you feel good about, people that care about you. I know our partner Ron Six is fond of saying, Amy, what I believe to be very true, and we treat our clients like family. Sometimes that love we show that you just described may be tough love, where we're telling you can't really afford to hold on to all of these assets, and we need to come up with a plan to get you to a better place. But we're going to treat you like family. I know you do, and if anyone doubts me, look at some of Amy's reviews online. Her clients think the world of her.
And Brad, even in a quick Chapter 7, I just want to say this real quick. You made your point about going beyond 3 to 5 years. Even if you're looking at Chapter 7 and you think, well, wow, that's a real short deal, that's a quick in and out. But your attorney is still with you forever for the point you made. So collectors don't pay very well attention. Collectors continue to sell your debt even after you discharge it in a bankruptcy. The new collector doesn't know. So here's just a quick example. Chapter 7, I did discharge 7 years ago. My client just brought me a collection letter on a debt we discharged, a fresh out of the gate debt collector for her, and put $1,000 in her pocket and the collector fees for doing it. So make sure you pick somebody who you violated,
Amy, I think we may have a little bit that storm that we talked about earlier may have hit Huntsville. Your frame is freezing up a little bit. In fact, we just lost Amy for a second there, folks. Hopefully she'll survive the storm there in Huntsville and be able to log back in here in just a second. But I do want to, if you didn't hear what she just said, if a creditor writes you about a debt, or a collector, specifically a debt collector, contacts you about a debt after your bankruptcy, a debt that was discharged in your bankruptcy, that's a deceptive letter. And it's almost certainly in violation of what's called the Fair Debt Collection Practices Act. And with the Fair Debt Collection Practices Act, there's strict liability, which means if we can show a violation, that creditor needs to write you a check for $1,000. And that $1,000 is all yours. They have to pay our fee in addition to that $1,000. So we're certainly going to help you to protect yourself even after your bankruptcy is completed. Our obligation goes well beyond that. I have a few more questions here, and I'm going to address them on my own until Amy can hopefully join us again. But we'll in a chapter 13 debt reorganization. There she is.
I'm back.
Oh, good. We missed you.
I don't know if it's the weather or what, but
I think it probably is. It's you started to stutter a little bit on screen and then went out, but. Thankfully, the screen looks better now with you back on it, Amy. I was just getting back, and I think this is a good question for you. With a Chapter 13 debt consolidation, will my creditors stop harassing me? Because that's a big thing now. I'm home, and I'm getting these calls. I can't pay my bills.
Good question. I caught your question, even though we had an interruption, I think, with the weather and the train outside my office window. Yes, stops credit harassment. The minute you file a bankruptcy, your creditors can't call you, can't come by your house, they can't send you letters, emails, nothing. It puts what's called an automatic stay into place, and that's whether or not you file Chapter 7 or Chapter 13. So it is immediate relief to you. As we were talking about when I went off screen, if a creditor violates that, we were talking about if they violate it after the discharge and after the bankruptcy is over. But if they contact you during your active bankruptcy case, that is a violation of that automatic stay. Creditors know that. So they should not contact you once you file the bankruptcy case. They receive notice from the court. They have an opportunity to file things with the court, but they do not have the right at that point to contact you direct in any manner.
And if they do, similar to with them contacting you after the bankruptcy, we'll seek damages. If it's blatant, if they should have knowledge of the bankruptcy, or you've told them about the bankruptcy and they continue to bother you, we'll certainly pursue damages on your behalf because they're violating an order of a federal bankruptcy court by contacting you. This is an important one, Amy. What does it cost to file a Chapter 13 bankruptcy?
That's a good question, Brad. I thought you just said you shouldn't just ask that question out of the But no, it is good. And, it can vary. Now, typically with a Chapter 13 in most districts, it's going to be very little money up front to file your Chapter 13. That's another benefit to the Chapter 13 is that you can include your attorney's fees and actually your filing fee and court costs in with your monthly payment plan. You do not have to pay your filing fees up front. And from each office, each area we practice in, it's going to vary a little bit from district to district of how much is due up front. In most cases, it's very little. Could be nothing up front, or could be as little as $100 up front, or some small amount. That's again something to talk to your bankruptcy attorney about. That's again, to Brad's point, why we offer a free consultation, because there may be different reasons and everyone's situation is different. So we can evaluate your situation and tell you an appropriate fee for your case. And like I said, we work with you, on getting those fees paid if you need to.
Yeah, folks need to know. We understand why you've come to see us. We understand you're here and you've contacted us because you can't pay all your bills. And so the last thing we're going to do is hassle you about fees. If there is money that needs to be paid up front, either for a Chapter 13 or a straight Chapter 7 bankruptcy, we'll work out a convenient payment plan for you. We'll do it at your leisure and at a pace that works well for you. We're certainly going to be the last people hassling you for money. So we understand why you've called us, and we will work with you on fees one way or another. Amy, those were all of the questions that I had. Is there anything important that I haven't touched upon that you think folks need to know about Chapter 13 bankruptcy?
Well, Brad, it's just I would like, and because of several phone calls I've gotten lately, kind of back what we talked about at the beginning of the post, people don't know what to do right now. I was telling a TV reporter this the other day when I did a little news thing. No one knows where to turn. You may have never faced debt issues before. You may never think you need to file a bankruptcy before now, and you don't know what to do. Call us, talk to us, because so many people are not aware of a Chapter 13. If you've never had any reason to be in a situation where you have trouble with debt or never had a family member who that filed one, people don't know that help is out there. It's just not as common knowledge as the Chapter 7. I've had several people call me lately who were just, I need to file a Chapter 7. Well, let's talk and find out what's going on with you. And the end result is they wind up needing to file, or a Chapter 13 is a better option. So it's something that you do your research. Our website, again, as you said, is a great resource because the blog is searchable and there's a lot on there about Chapter 13. It can just be a big relief and a big help. And a lot of my clients, I have several clients who just, you don't want to be in bankruptcy per se, and you can't help why you've gotten here, whether it's because of the recent pandemic or something else that takes place in your life or has in the future or in the past. Sometimes medical bills can drive you to, many times medical bills can drive you to bankruptcy. So you may have experienced something out of your control, and it's not that you don't want to pay your creditors. And if you have the income coming in and the desire to pay creditors, maybe you just need a Chapter 13 to reorganize the debt, make it less overwhelming, and still feel, you can still have that feeling of taking care of your creditors. And, if you feel that that's the thing you need to do.
Amy, I know you're sitting in your office right now, and I'm sitting in my office, and I look at the chairs in front of my desk here, and I think of all the times somebody has sat down in the chairs in front of my desk, and they're thinking to themselves, why am I here in a bankruptcy attorney's office? Nobody ever expects to get to this point, but you kind of have a lot of folks kind of have a stereotypical picture of somebody that files bankruptcy in their mind. They may think it's somebody that's been lazy or not managed their finances well. In so many cases, I know Amy will agree, it's somebody, good people like you and I, that something bad has happened. It might be a health problem. It might be sickness, injury. It could have been a divorce you went through, loss of a job, or right now, just not being able to work. We do the consultations that we offer confidentially. They're free. And again, we have experience. So I challenge you folks, now is the time to be proactive. Write down our phone number now. Go to our website. Phone number's on the screen, but it's 877-581-3396. Call us, schedule a consultation, just talk through things with us. It'll be confidential. You're going to get heartfelt and good advice, and we're going to tell you the step that's best for you. I do want to ask you, we are going to continue to do these Facebook Live events every Wednesday at 1:00 p.m. We will talk about different issues that are important to both our clients and folks out there who think they may need some sort of help in the future. And this is just a way for us to share information and let people know we care and that there are options available. So if you know somebody that may need some help, encourage them to all of our past Today's Show and the past presentations we've done are available on Facebook. You can go back and watch them later, or tune in next Wednesday at 1:00. But take charge. Fear is something that you can overcome. The anxiety is only going to continue if you allow it to go on. Get a grasp on your finances. Let somebody with experience dealing with these issues advise you. Amy, I really want to thank you for participating today. This has been, I think, great. You provided a lot of great information, and I'll say it publicly. Thank you for all of the good work you do for our clients. You're really a great friend, and you're a great member of our firm, and we appreciate you.
Thanks, Brad.
On behalf of Amy and on behalf of myself and really all of us at Bond and Botus, God bless and good luck, and goodbye for today, but we're here if you need us. Thank you.
Thank you.